Welcome everyone at today's panel. This panel is hosted by TILT, the Tilburg University of Law, Technology and Society. And our panel is called Timing the Right to be Forgotten. The panel consists of Meg Ambrose, Assistant Professor Communication, Culture and Technology at Georgetown University in the United States, Ivan Szekely, Research Professor at Central European University and Board Member of the Eotvos Karoly Policy Institute in Hungary, Jeff Ausloos, Doctoral Researcher at ICRI, University of Leuven, Faculty of Law, Giovanni Sartor, Professor Legal Theory and Legal Informatics, Law Department, European University Institute Florence and the Faculty of Law, University of Bologna. And last but not least, not even last, Jay Stanley, Senior Policy Analyst and Editor of the Free Future blog at ACLU USA. Next to me, Ronald Leenes, Professor Regulation by Technology at Tilburg University. We also have Regulation by Technology. This is our device that times our panel members. And I'm Paulan Korenhof. I'm a PhD student at Tilburg University and Privacy and Identity Lab. Before we start the panel, I would like to tell you something about the background of this panel and mainly why we chose the specific angle of timing the right to be forgotten. To start with, we have human memory. The human memory stores information and then retrieves the information at a later stage. A bit slow sometimes. However, the human brain is limited in its capacity to store information, so over time we generally have a tendency to forget. However, the human brain is really plastic in its nature and we tend to use external sources to extend our memory capacity, like agendas, notebooks. By using such external memory stores, we went from a brain that automatically forgets towards a forgetting by selection in our automatic memory stores. For instance, if we have a bookshelf and one bookshelf to fill and we keep buying new books, we have to select which ones we keep and which ones we disregard. Information systems now are changing that increasingly, and we're moving from forgetting by selection, which was needed, to a remembering by default, because it takes more and more effort to erase digital information than it is to keep it. The internet is a great example of a memory store where we store a lot of our information, and the cloud. And on the internet, we also share the memories, the external memories that we store there with other people, and we can also see and consult their memories. Not surprisingly, this has led to worries. Some of these worries are represented in the article by Jeffrey Rosen, The Web Means the Add-on of Forgetting, and by the book of Victor Meyer-Schoenberger in Delete. And there are a lot of other examples of people who've been worrying about the so-called everlasting memory of the internet. However, don't panic. There is progress in legislation. In the new General Data Protection Regulation, there is a right to be forgotten or erasure in development, which after the Libe changes might become a right to erasure. And this right supposedly helps us to get rid of unwanted digital pests. However, not only the individual is at stake with the right to be forgotten that enables a forgetting by selection, but also cultural, historical interest, scientific interest, and the freedom of expression. These different interests have been balanced with regard to their time and the way, with regard to their meaning and the way we use them. However, time until now has been a factor that has been relatively underlined, and this panel aims to change that. The background question of this panel is therefore, with regard to the right to be forgotten, does time play a role, and if so, how to operationalize it? And now I give word to our first speaker, Meg Ambrose.
Thank you, Paulan, for inviting me, and thank you for choosing such an interesting aspect of the right to be forgotten to talk about today. I'm actually not going to talk about the right to be forgotten very much, and not in very much detail. I'm going to talk about informatics and how time changes digital data and the associated rights with that data. And then I'm going to describe an information life cycle outline that is intended to inform the right to be forgotten to more accurately tailor that right to the information landscape that exists and some of these interests that are embodied currently in the exceptions. So, as Paulan said, the right to be forgotten is sort of a reaction to this concern about the permanent digital record, right? If it's online forever. We even see this in public service announcements to children on the Disney Channel. But actually, digital data is very fragile. I'm going to try to be very fast. So this is just a laundry list of reasons why digital data decays. And over here are a number of examples of spaces and content that has disappeared from the web. And I'm sorry I'm not going to go through this research in great detail, but computer scientists and information scientists have tried to measure persistence on the web to determine how long content remains accessible, because this has been determined to be a crisis for information scientists and information historians who look at preservation efforts. And while I'm not going to go through all of these different research projects, all of them had different goals and different methods, we do consistently see that only about 10 to 15% of content remains accessible after a year. And I think this has something to do with public interest because these graphs look similar. These are the Google Trends charts for two very embarrassing incidents that made the national news in the US. The first is Caitlin Davis. She was fired as a professional cheerleader when these images were found on Facebook, and the drunk, passed out person has a swastika sharpied on them somewhere. And the other one is Alexandra Wallace, also known as the UCLA racist. She posted a YouTube video of herself making derogatory comments about her UCLA classmates, made waves, people made remixes of the video, but you can see that the interest, the number of people that searched, which is what Google Trends measured, had this spike of a few weeks, and then it really dwindles, and both eventually there's no one is searching for these people after a few years. It's almost nothing. And so I think that data controllers are certainly motivated by public interest, and so that's probably why we see some of these inaccessibility rates. But also, public interest is, of course, relevant to the right to be forgotten and part of the exceptions to the right to be forgotten. And so this is just one of the tools that show how fleeting some of our public interest can really be. So from a data management perspective, these are a few of the characteristics of aging information. So we can see that interest decays, use decreases, content becomes stale as it's absorbed into the knowledge base. It can be aggregated into other data. It loses some context, which can make it less accurate and less reliable. And these are some possible effects on the data subject. Over time, the harms can accumulate from lost opportunities, and certain injustices from inaccuracies can develop. And we may see a decrease in incentives to alter actions or interactions. So while we may not know why certain information is going to last for certain time periods, we can make a few assumptions about why information does remain. And we can say that the data controller is going to maintain, he or she is going to upkeep that digital data as long as they have the interest and resources to do so. And I think that's based on, is driven by value, and value can be a continued interest in wanting to communicate the same thing, a utility in the information either internally or externally, or public interest. So what I did with these ideas is I tried to build an information life cycle, and what I came up with two different uses: immediate information needs and remote information needs. Immediate information needs are, these are users who want information to make decisions about the current state of the world. And remote information users are users who are trying to uncover previously unknown insights into the past or the future. So if you want to deliver a package, you want to know someone's current address, and you're an immediate information user. If you want to predict where migratory patterns are going to occur in Canada, you would be considered a remote information user. And then what I did was took these ideas of changing values over time and broke the information lifecycle into three phases. So at the distribution phase, when information is newly released into the world, it's got a peak interest, use, relevance, accuracy, and context. All of those things are embodied in that data or the data surrounding it. And then as time moves forward, we get into the record phase, where you're not really sure about the data's interest in the data, or its relevance, or its accuracy. It may become unreliable, or it may require you to do some work to figure out how relevant that data really is to your search. And then in the expiration phase, the information remains as it always has, but the world has changed. So this is content that represents data from a time in the world, but the world has moved on and no longer represents that part of the world. And so we kind of see opposing interests. For immediate information users, we just have a decline of value as it goes through this. You don't want to rely on expired information. But for remote information users, value may increase as time goes on. As information changes, it may become obvious that this is a trend or something to look into as a historian. So I realize this is a bit abstract. So let's say that you're going camping in Montana and you want to know how many wolves live in Montana, are currently living in Montana. You can look at the newest report that says the head count of wolves in Montana. This is reliable. It's probably contextualized with information about other animals. It's very relevant to your search. But if you looked at, say, a report from 2 years ago, you may not be sure if that information is reliable. And if you looked at, say, an encyclopedia from 10 years ago, and it says there are 12 wolves in Montana, you could be in serious trouble, because I think there's a lot more wolves in Montana than 12 now. But if you're a remote information user, you may be very interested in how many wolves exist at any given point in time. Let's say you're doing a study of trends on how endangered species reintroduction programs are working. And so both of these information uses are really important, but they're very different, and time changes the value associated with that data in very different ways. So this is relevant to the right to be forgotten. The first point, this is my last slide, the first thing is that the right to be forgotten may not be that important to a lot of information. A lot of information may disappear before it has a huge impact on the data subjects' lives. I think this is actually very bad. I don't think this is how we should go about this. We should be thinking about this in terms of stewardship and preservation, and making some of these hard decisions about what we should hold on to and what we should let go. But it does make the right to be forgotten, I think, somewhat less dramatic than we have been talking about. It also, I think, provides some tools for making some hard decisions about the right to be forgotten. We have this idea that things should be held if they're in the public interest, and so we have tools to show that things have not remained in the public interest for a given time. We have hit counts on pages, on pictures. And also we can see that if a data controller has not linked to, has not mentioned content in years, then maybe they've lost interest also in maintaining that content, even though it still remains accessible. And I would say the last two comments that we should consider enforcing the right at the expiration phase, where the data is dangerous to both the data subject and immediate information users, but should encourage limited access preservation without deletion to make sure that our remote information users can still utilize that data.
Thank you. Thank you, Meg. Can someone switch this microphone on? No. Okay, thank you, Meg, for this, this first introduction. So one of the things you're saying is that a lot of the information has a sort of a natural decay, either by technical means or because people take off information off the net. And let's say that that's 85% of the data that's out there. But then a couple of questions are, I mean, the right to be forgotten is something where the interests of the individual are at play. And how does that feature in this 85%? Is it the case that basically the 85% of the information doesn't affect individuals in the end, and 85% of a lot of information that's out there is still, or 15% is still an awful lot. And if sort of the stuff that we're talking about, information affecting individuals or their reputation or their identity or what have you, if that's in the 15% ballgame, then that's still a lot. Do you know anything about sort of the distribution of the kinds of data in the 15%?
Well, no, I don't think that we have good information, good research on what information remains. We do know that .gov sites fall off the web the fastest, which I think shows just how bad our preservation efforts really are at this point. But you're right, 15%, I'm sure it's more than 15% that, lasts for these first few months, and it can have a great impact on the data subject's life. Really, if you think about it in terms of a life cycle, a lot of data has a really short life cycle, and some of this data has a very long life cycle. And so the data subject's interests can be accounted for with these other public interests and the data controller's interests, even as it remains accessible. So it can still cause harm, but those interests, I think, do need to be accounted for, but we shouldn't necessarily just be keeping information up because it's up.
Thank you, Meg. For the audience, I'll explain something about our format. We have a speaker, then our moderator asks one question, and then at the end, after all the panel members had their presentation, then the room is open for comments by the audience. Ivan Szekely, go ahead.
Thank you very much. Meg concentrated in her presentation on the changing value and use of information. I will follow a different approach. I try to set up an inventory of specific points in data processing when it's still necessary, or if it's possible, to enforce the right to be forgotten and to erasure. The essence is here. I could have called the whole presentation, when is it possible or when is it necessary to enforce the right to be forgotten? I will show you 9 cases, but I start with number 1. Not with number 1, but with number 0, because this is a preliminary step. Even before the recording of information takes place. This is a kind of preventive measure against a situation where the right to be forgotten might be necessary. For example, if I see that somebody is preparing his camera to take a photo of me, I can say, no, please don't take a photo. I would not like to be recorded, and I would like to be completely forgotten. Then, so that's yes. The number 1 case, that's immediately. If I still hear a kind of shutter click noise, I might say, I'm sorry for using you as an example, that I already told you that I don't want to be on the picture. Please delete it immediately. If you are not taking pictures on a kind of legal authorization, then I can have it deleted immediately. So that's an immediate enforcing of the right to be forgotten. And this is why in some countries, this is a de facto industry standard that recording equipments make a kind of noise in order to call the subject attention. Case number 2. When a legal deadline expires, there are quite a few legal deadlines in legal systems. For example, in civil law, there is a general term of limitation until a deadline you can lawfully process personal data, even if you stopped your connection, your business with the data subject. And this can be regarded as a kind of extension of the purpose limitation principle in time. And in criminal law, there is something similar. The authorities are obliged by law to register and to keep in the registry information or prior convictions. But after that time, they must delete it, and the person can get a clean certificate of good conduct. This is generally just an obligation to the controller, but the subject may require deletion of her data in other data controlling systems too. Number 3, when the conditions of lawful data processing are not met. There are some cases like this. For example, you are registered somewhere without your consent, and you recognize that. Or the purpose does not exist anymore. We have a special case here in direct marketing. If you want to be forgotten in a direct marketing company's mailing list, they will not delete your data because the laws on direct marketing in many countries oblige them to keep your data and put it on a separate list, which is called the Robinson list, in order to filter you out from subsequent mailing lists. So it's not the enforcing of the right to be forgotten, only a sort of limited use or filtered use of your data. Case number 4. At predefined or default dates, there are some user-centric identity management systems like Prime, although Prime is rather a vision. That means that if you want to delete something, what you posted on the internet, all Prime-compatible computers will delete it immediately. Victor Meyer-Schönberger's suggestion is somewhat similar, that each piece of personal data should have an expiry date, and after which they would disappear. And of course, the expiry dates may be changed before the deletion of the data, so it doesn't mean that you will lose it when you set the date. Number 5, case number 5, never. There are some cases where you can never delete your data or never can be forgotten. And this is a case with personal data of public figures generated in connection with their such activities, of course not with their private life. And the same applies to personal data lawfully published in the media. But the big question is whether it's applicable to online media too, because one of the fundamental purposes of the right to be forgotten in the present form was to counterbalance the unexpected consequences of using new media. Number 6, it's a gray zone. The data of the deceased. Naturally, any kind of rights can only be enforced by the surviving relatives and not the deceased person, him or herself. And in a sense, it's not the protection of personal data, but the protection against the injury to the memory of a deceased person. You can envision the data, the personal information of a deceased person as a comet on the sky, a celestial train of a comet, which at the beginning, close to the head of the comet, is very, very personal, it's almost living, but through the passing of time, it gradually loses its personal nature. At the end, it becomes sort of historical data. Where's the deadline? Of course, you can argue. But what's interesting is that data relating to the deceased person may also be relating to the surviving relatives. Case number 7, it's a special case. The expiry of what I called the obligatory publicity or enforced publicity. There are some scenarios in life, for example, court cases. Court hearings are open to the public as a main rule. There are some closed hearings, but main rule, they are open to the public. So the personal data revealed there can lawfully used by those who are present during the court procedure. This obligatory publicity, however, expires sometime after the judicial process, and in the case of criminal procedures, they may become sensitive personal data. So from one extreme to the other, which should be deleted, or you can enforce your right to be forgotten in that case. And the last case is also a special case, personal data or the right to be forgotten in memory preserving institutions, whose main function is to preserve memory, especially archives. So there's a great hype from the archival community, and partly I belong to this community from another side, but I think these kind of declarations signed by more than 50,000 people, started by the French archivists, that we will erase our future history if we let people to use these rights, are based on a serious misunderstanding of the situation. First of all, the administrative archives, one of the two main types of archives, are operating under legal obligations and not by our consent. The tax office will not ask my consent whether they can process my data. Historical type archives are processing personal data by legal authorizations, and again, not by consent. So they also don't ask us. So we cannot enforce our right to be forgotten in these archives. Plus, there's a whole sentence, a whole provision in the draft regulation of the EU that this right shall not apply to processing for historical, statistical, and scientific purposes. And there is an initial gap in archives. If you transfer something to the archive, there will be a gap, sometimes a very long gap, when you cannot access the data, so you cannot delete it, and the archive can say that, yes, we would be willing to delete your data, but unfortunately we cannot access it. So that's the summary. You can see all the cases which I enlisted. These are the specific points in data process, in the life cycle, if you like, of data processing, when you can or you need to enforce your right to be forgotten. But as a closing sentence, I would like to add that in all these cases, it's not the right to be forgotten what is important. What is important is personal autonomy and choice.
Okay. Thank you. Thank you, Ivan. That solves another problem. So we now have Meg talked about a sort of life cycle of data. To some extent, Ivan gave a very concrete interpretation of what such a detailed life cycle could look like. And so in both cases there was talk about a sort of natural decay or decay of information, but on the other hand there are also a number of discrete events that may trigger a need for erasure of data. And maybe a question for both of you. What is your idea? Is it a mix, really a mix of these two kinds of things, or is sort of a flipping point, a discrete time in more important than this sort of decay? For instance, if somebody graduates from high school or university, that is typically then you assume a different kind of role, and therefore things that you've done in your previous role may be, well, embarrassing or what have you, and that might be a reason to get rid of that data. Or should we rely on more that will happen automatically, as Meg pointed out, in that others are no longer interested in those embarrassing events after some time? What are your thoughts on that?
Can I have the wireless mic?
Does that work?
Okay. Thank you. I think most of us don't realize the need of be forgotten until you get into a situation where it becomes important. And this is one possible situation what Ronald mentioned. If you want to get rid of your previous life, you change, you enter into a new phase of your life. And if I may add that a lot of American people don't really grasp, don't really understand the European concept of privacy and dignity. They understand very well the notions of freedom and things like that. I don't want to oversimplify this. But this specific case, the right to be forgotten, is something they seem to understand, because in the classical American ideologies, the right to start a new life was always part of the game. So no matter what you did before, you must have a possibility to leave your previous life behind and go west and so on. So this is something which may be common in the American and European approach to the right to be forgotten. But to your question, I think you realize that you need to get rid of something if you get to a situation and not normally.
I think what I would say to Ivan's presentation is that a lot of information is not going to make it to the archive state. It's not going to get to the hands of the librarian because it's already gone. And I think that is bad. But all of, and like you said, Americans, we don't have a lot of these other instances, right? When the consent expires, when obligations kick in, all of those things, we don't have those in place. But we do understand reputation. We may not understand dignity, but we understand reputation. And so the right to be forgotten, I think, gains popularity under that that cultural aspect in America. And the life cycle of a child and changing who you are and who you want to be also has to be balanced with accountability. I think that's one thing that we're really having a hard time with. The idea that your reputation is really, really important, but that for a certain amount of time, people should be accountable for their actions.
Thank you, Ivan. Thank you, Meg. We're going to the next speaker, Jeff Ausloos.
So, good morning, everyone. First of all, I'd like to thank Paulan and Ronald for inviting me to speak here today. Though I have to admit, I did get a little nervous when I was first invited, because not only is this the first time that I'm actually presenting at CPDB myself, but it's also about a very vague and hard to grasp topic, time, which is something that lawyers generally are not that comfortable with. But nevertheless, it did trigger my curiosity in looking more closely at what role time actually plays in the legal framework with regard to the right to be forgotten. So my presentation today aims to identify some of the relevant legal frameworks and case law with a particular focus on the general right to privacy and data protection. So I'd like to start off with a terminological issue. So over the past few years, the so-called right to be forgotten seems to have been used as some sort of umbrella term to refer to different situations and different legal regimes. So the general right to privacy, right to personal portrayal, data protection, defamation, etc., etc. But when looked at in the context of the general right to privacy, it is usually applied to shield individuals from being confronted with certain aspects of their past in a disproportionate, unfair, or unreasonable way. And a classic example is the ex-convict who is confronted with his or her past in the media years after the fact. And because it is primarily invoked in situations where an individual's personal life is publicly exposed, usually by the media, a careful balancing exercise with other fundamental rights will be imperative. One of the key criteria in making this balance will often be the passing of time. So in the Österreichische Rundfunk case for the European Court of Human Rights, the court specified that the lapse of time since a conviction and release constitutes an important element in weighing an individual's privacy interests over the public's interests in publication. But then in another case, the court decided something differently, because this case concerned the publication of a book by the private doctor of former French President Mitterrand. And so here the court held that the lapse of time was an argument in favor of the public's interest over the privacy and medical confidentiality protections of the former president. So when based on the data protection framework, the right to be forgotten, or rather the right to erasure, seems to be more mechanical and straightforward, or at least in theory. So under the current directive, the right can be invoked when the data processing does not comply with the provisions of the directive. In other words, it looks like the data subject could invoke his or her right to erasure when the controller fails to fulfill its obligations or ignores the data subject's rights. And three of the most relevant elements in the context of this panel here today probably are the purpose specification and use limitation principle, the need for a legitimate ground, and the data subject's right to object. So the purpose specification principle actually constitutes some sort of benchmark against which the processing of personal data will be assessed over time. And besides having to be specific and explicit, the purpose also has to be legitimate. And it goes without saying that the legitimacy of the purpose of processing can evolve over time, depending on a variety of factors. So on top of that, over time, personal data might become unnecessary, irrelevant, or inadequate to achieve the original or a compatible purpose. So secondly, the processing activities will permanently have to be tested against the legitimacy grounds in Article 7 of the directive. And this is particularly relevant when the processing is based on the last legitimacy ground, which requires a careful balance to be made between all rights and interests at stake. It goes without saying that these might evolve over time as well. And then thirdly, in principle, the right to erasure can also be invoked when the data subject has successfully exercised his or her right to object. And in order to exercise one's right to object, it is necessary to put forward compelling and legitimate grounds. And it goes without saying here as well that these grounds can include the time factor too. So in the currently still pending Google Spain case, I checked it right before the panel, there's still no judgment. The Court of Justice, the Advocate General released an opinion in June though. So here one of the primary arguments of the original plaintiff was the passing of time. So the National Court explained that today it is possible to create very detailed personal profiles in just a couple of clicks, with information that used to be difficult to find. And the lack of territorial and temporal limitations to the dissemination of information constitutes a real threat to the protection of personal data, the court said. And the court further specified that originally lawful and accurate personal data may become outdated over time in the face of new events. So some of this information might actually generate social, professional, or personal harm to the individual. Now finally, I'd like to say a few words about the draft data protection regulation. So Article 17 on the right to be forgotten and to erasure, already rebranded to the right to erasure, specifically aims to give back some control to individuals over their data. And without wanting to go into detail on this provision, it is worth highlighting that the article does refer to the concept of time in paragraph 7. So this provision stipulates that a controller should implement mechanisms to ensure that the time limits established for the erasure of personal data are observed. And the regulation also requires these time limits to be specified in the information provided to the data subject. All right, so let me conclude. First of all, technology makes it ever more easy to store and find all information. Just think of the digitization of old archives, facial recognition, geotagging, etc., etc. And this trend evidently upsets an increasing amount of individuals. And depending on the relevant facts in each case, a number of legal frameworks might be used to request certain information to be deleted. And the general right to privacy seems to be particularly used in situations where the information is made public by the media. So from ECHR case law, it can be deduced that the time factor can either play in favor of removing the information or keeping it available. So in any case, it seems from all the legal frameworks that might be applicable, data protection law is an increasingly attractive path to take. Because not only does it have a very broad scope of application, but unlike most other regimes, it does not require falsehood, malicious intent, or widespread publicity. So regardless of the legal regime that is used, it seems that virtually in all of these cases, a balance of interests and rights will have to be made. And in quite a few situations, time will play a relevant factor in making this balance. So to give you another recent example, it is worth referring to the Advocate General's opinion in the DRI and Zeitlinger case before the Court of Justice, released just last month. So in this opinion, the AG specifically claimed that the data retention directive is incompatible with the Charter of Fundamental Rights. And one of the reasons he put forward was that the directive does not respect the principle of proportionality, in requiring the data retention for up to 2 years. Because according to the AG, there's no justification for extending the data retention period for anything beyond 1 year. So in short, it seems that the passing of time can be used to argue both ways, for or against removal. And the importance of time in determining the merits of removing information will be different in each individual case, but should not be overestimated either, because eventually time will just be another factor in assessing the balance of rights and interests. Thank you.
Okay. Thank you, Chef. It was already, okay, so we're now swapping places. Yeah, it's a bit of a, okay. It was already a bit complicated because time is one of the factors that is relevant in determining whether information should be deleted or not, or whether an individual would have to have the right to have information deleted or not. But it's further complicated by the fact that you have multiple players at stake in this whole process. And the Google Spain case is a clear example there, where I don't want to go into the details of the case, but basically it boils down to there was information published about an individual, a tax debt, and this individual 10 years later or something wanted to have that data removed from the newspaper, and the newspaper, the online version, the newspaper refused to remove the data from their online version. And then the individual went to Google because others, us, can find the information in the online newspaper through Google searches. And so the question there is, we have two players. First, the newspaper that had an official function in printing this information in the first place, maybe. And then Google making it possible for individuals to find that information, which is a much broader audience. So, Chef, do you think, and that is sort of also looking at the potential outcome of the Google Spain case for the court, does it make a difference for the newspaper or for Google whether or not they should remove the data of this individual or not? And I think this is the appropriate time to flip around the microphone. So you have the primary data controller, you can request to have data removed there, and there's Google that points to this data controller, and Google is in a totally different game, if you will.
So yeah, first of all, I'd like to do some promotion. Tomorrow, the last session in La Cave is exactly going to talk about this question. For now, I mean, the difficulty is, in this case, was whether or not Google is a separate data controller. Huh? And because so whether or not you can look at it as two separate data controllers, the publisher, who had the legal obligation to publish information, and you can raise a whole lot of questions whether or not there should be a time limit on that as well to publish bankruptcy proceedings. Or online archives of newspapers. And then there was a question, Google as a separate entity do they have some responsibility with regard to keeping this, to referring to this information? So it was argued that it was a separate activity of the search engine. And then the question, of course, is, how is Google going to make this balance, and are they well placed to make this balance, taking into account the passing of time, but also other factors?
Yes, but in the case of the newspaper, you could argue, in line with the previous speakers, that they have an archival function. So it is relevant that that information remains. Whereas in Google, being a separate data controller, at least that's how I interpret how things should be, at least. That they have different interests, and that the factor time should play differently for Google than for the entity with an archival function.
Yes, I'm pretty sure that time is one of the factors in their over 200 functions in the search ranking algorithm, but it's I mean, in the end, the question is whether you can, as these persons, how far will you go, right? Every person that points to this information should make a balance whether or not this information is still of public interest. Okay. And you could also argue, what's the goal of, even if there's a value in keeping these online archives, what's the value of having them if people can't reach them? And you could argue then search engines are a crucial part in the internet ecosystem to reach these archives.
Okay, thank you. Maybe that Giovanni can shed some light on that in his presentation upcoming now. Yeah, we changed the order.
Okay. Okay. I was expecting to come later. Okay, so in my presentation, I will try to generalize in a way the discussion on the right to be forgotten into a more general discussion of data protection through time, and try to provide a framework in thinking about this matter. So I will assume that time exists in some ways, and it has an impact on data protection. And also, I will assume that multiple rights and values, we mentioned some of them, are affected by the processing of personal information, and that their balance or trade-off evolves over time. And finally, I assume also that this evolution should, to some extent, inspire the legal regulation in particular, of the right to be forgotten. So I will try to examine what are the possible time-dependent dynamics of the relevant legal interest, and try to sketch some consideration on how they can and should impact on normative entitlements with regard to data. There are a huge amount of legal and philosophical issues involved in this, but none of them can be addressed in 10 minutes, so I will skip all of them together and go into my presentation. So, as we have seen before in the presentation that preceded me, the right to be forgotten covers somehow various aspects. I will not consider here portability, obviously. I will not consider the right to withdraw consent, on which a lot have been said. I will only focus on the issue which was addressed also in the last presentation. What happens when the persistent publication of the data, the persistent processing, more general, is justified on the balance of interest at stakes? And what happens when, through time, the balance is reversed? And then I will add some consideration on one further issue, which I think is very important. What difference does it make to have sanctions, rather than simply an injunction to stop the continuation of the processing? So, what are the interests at stake? I will not say anything about that. You know what they are. There are two big sets of interests. I call them pro-processing interest. which cover freedom of expression in the cases I will focus on, democracy, information, transparency, public deliberation, but also economic interests. And there are interests against processing, maybe the privacy of the person involved, but also reputation, identity, dignity, right to a fresh start. All of these are involved in issues such as the persistent publication of information concerning a bankruptcy, or information concerning a crime, or any behavior that whose information about which may be damaging for the data subject. So what may happen through time? The first, the simplest pattern is the one that you can see on the screen. It's no mathematics, just a way of sketching the ideas of these trade-offs. So the continuous line that you see here is meant to, the unbroken line is meant to indicate what are the advantages, that is the extent to which this particular kind of processing promotes the interest that it does indeed promote, the rights, values that it promotes. For instance, in the case of information about a crime, it will be the value of freedom of expression of the publisher, but also information to the public. Maybe there will be issue concerning a democratic debate if the crime concerns political activity, and so on. What are the interests against? The interest against would be the interest of the data subject that are affected by the processing. Let us assume a different kind of setting, for instance, information about a contract, and let us assume that the transaction is ended and that the purpose of the processing is achieved. From that moment on, there is no longer, so you can see from here, there is no longer any valuable interest which is satisfied by continuing the processing. There is also only the loss. Obviously, at this point, the good thing is to stop the processing as we are required by the idea of purpose limitation. As you can see in these subsequent slides. So what the law should do, as it does to some extent, is to interrupt, to induce the party to stop the processing at that point, because no gain, no advantage with regard to any legal values is delivered by it. On the contrary, there is a loss. The pattern may be different. It may be possible that there is a limited processing that limits damage, but gives an advantage that outweighs the damage to some extent. Imagine, for instance, that certain information about a contract has to be kept for accountancy purposes, restricting their circulation. Maybe also then another situation will take place. Maybe that there was a relevant interest for keeping the data up to a certain point in time, but then even a limited processing after that point in time would have a negative impact on the legal interest at stake that outweighs the beneficial impacts. Imagine, for instance, that somebody says, let us keep the information that is taken from street cameras, but in an encrypted form. This is going to be less damaging for the data subject. Yes, but still, after the deadline has expired, it is better, all things considered, to erase definitely those kind of information. So, two assumptions to address the case of the balancing of the interest, which is what I'm going to refer to in the subsequent slides. So consent is not at issue. The assumption is that there is a different ground, legitimate ground for processing the data, in particular freedom of expression, right to information. What may happen through time? There are two assumptions, sorry. The first assumption is that as time goes by, generally, both the interests that support processing become weaker, so, or rather the impact that the processing has a lesser impact on those interests, and the same happens also for the interests that support processing. Here you have an example. It may happen that there is the impacts on the two categories, two sets of interests decrease, but the interests supporting, against the processing are prevalent as they were at the beginning. Imagine, for instance, publishing health data of a person who has, this person who has no particular significant political or public role. In this case, it is a damage from the start, and the damage continues to outweigh the possible advantage. Different pattern may also take place. It may be that it is more significant, on balance, more important to continue to process the information, for instance, distribute information about the involvement of a politician in a scandal, and that this continues through time, even though the news become less and less relevant. But when do we have a kind of context that justifies the right to be forgotten, that justifies oblivion? When you have this kind of oblivion cross, so when you have a situation when at the beginning the impact on the pro-processing values, pro-processing interest is more significant, so there is a gain, which outweighs the loss, the damage to the data subject, but after a certain time after a certain point in time, we call the reversal time, there is an inversion. From that point on, the damage outweighs the benefit. So when this is the case, what shall we do? Should the law do something? First of all, are there cases where this is the case? Cases such as the one that we mentioned of an old crime or bankruptcy, information that is not so relevant after a certain length of time. Does this cross take place? I would argue yes, it does in some cases. So there are some cases when the balance becomes negative. At the beginning, it was better taking into account all interests, rights, values at stake to process the information. At a certain point of time, it becomes no longer legally optimal, legally preferable. There are also cases, as it was mentioned by Meg, if I remember, in a previous case, when you can have also a double reversal. So at the beginning, certain information, for instance, a bankruptcy, was relevant. Then at a certain point in time, it was no longer, the damage to the person was outweighed the benefit of having the information accessible. But maybe that person is now applying for a public job. He or she wants to become a member of parliament. At that point, the balance changes again. This would induce us not to delete permanent the information, but maybe to make it limitedly or inaccessible during that time, when there is a chance that this may happen. As it is shown in this way, maybe we have a different way of processing the information that limits the damage, and that enables us to reuse the information when the time has elapsed. So I believe that there is the justification for a right to be forgotten when this kind of context takes place. But we have a different sanction. How should the legal system induce the parties to behave as required? That is, to take down the information from the point in time when there is this inversion, but not before that it takes place. I finished? 2 minutes, okay. So, what if there was no legal regulation of the matter? Obviously, let me explain this slide. So here you have what we had before. So you have a legal gain, which is initially prevailing. At a certain point in time, the loss outweighs the gain, and therefore the information should ideally be removed or made limitedly accessible. Obviously, the parties, in the absence of any the parties, both the uploader and the provider, they have some interest in the information still being there, and some motivation for this to continue to happen, and therefore they will continue to distribute the information. So it seems that something should be done by the law if we want that the processing ends at this stage. Okay? But what if the law, as it seems, at least in the first version of the new regulation, what if the law punishes the continuation of the publication of the information after the request, the removal request, by imposing a sanction on the provider or upon the uploader? So let me explain this slide, which is a bit complex. So here you have the point where you have an inversion of the legal balance. It is better to remove rather than to keep. Here you have the position of the uploader. What is the uploader thinking? The uploader, unfortunately, it does not know when this happened. We are considering cases where the interest diminishes continuously. There is no jump, no discrete event where you say, at that point, it happened that privacy interest started to outweigh the interest of the supporting the publication of the information. So what happens? The uploader does not know. This is his loss. You can imagine that at this point you have the sanction, the amount of the sanction. But even before that, there is the probability of the sanction from the uploader's perspective. Okay? And since the uploader has a limited interest in having the information online, by considering the probability, the amount of the sanction and its probability, the expected loss will outweigh the gain of the uploader at a point which is antecedent to the point when the information should be removed. That is, a chilling effect is going to be introduced, which pushes towards premature removal. And the same, even to a larger extent, happens to the provider, because the provider has even a more limited interest in keeping that particular item online. And so, if you look at the provider's position, then a sanction imposed given the uncertainty of when the removal time, the reversal time happens, the provider will even more be induced to anticipate the removal. So freedom of speech, I think, will be seriously at issue. What shall we do? One thing is to establish deadlines. If it is possible, if it makes sense in certain areas to establish a deadline, then the deadline removes the uncertainty, and therefore it does not affect, it does not create that uncertainty that we mentioned. We may provide for injunctions. Also an injunction, as long as the activity prior to the injunction is not sanctioned, does not have this kind of chilling effect. Condition the punishment to bad faith infringement. This may also be an option, assuming that we can really identify the instances of bad faith. That is when the party knows that the balance has already been changed without any doubt. And what about the new regulation? Which seems, I think the new regulation seems to punish the persistent distribution of the information unconditionally, and therefore seems to have this kind of chilling effect in the instances I was considering, where there is a balance of interest and a continuous adjustment of the relevance of the processing with regard to the interest at stake. Thank you.
Thank you.
Thank you, Giovanni.
This is yours.
Okay, I think the graphs are very insightful. I mean, it clearly shows how time affects things and also should affect the balancing of interest. But I think we also need time to digest that a little. So hopefully there will be a version of the slides available for people to look at. You've talked about the effects of this for regulation, how the regulator should cope with these insights. But you coming from an AI and law background, do you see any role of algorithms in this, implementing these ideas sort of in the IT systems of the data controllers we're concerned with?
I think I cannot imagine the balancing to be done automatically. I can imagine tools for graphing possible trends and then clarifying the ideas on the person who's making the assessment, but I cannot imagine it to be. I can imagine visualization tools, for instance,
But maybe during Jay's presentation, you can think about whether Google Trends things that Meg showed could play a role in providing input to some sort of balancing thing. Okay, we move on to our final speaker, Jay Stanley from UCLA without slides, but we do have the. Okay, you want.
Great. Thank you.
We had a background slide.
Yeah. Okay. Let's put up. Let's remove this then.
Okay.
Okay. Go ahead.
Thank you very much. So I bring the American perspective to this conversation. In many ways, my organization, the ACLU, is deeply concerned about privacy. They pay me to be a privacy advocate. And we fight for the right of individuals to maximize their control over their information and how they present themselves to the world. And as Ivan said, I think it's a very American value to have the right to start over. We have the frontier, people would go west, and we're a nation of immigrants made up of people who many of whom sought a new start to escape a life in one or another old world. At the same time, of course, the United States, as everybody probably knows, is probably the most absolutistic country when it comes to the right of free speech. And within the United States, my organization may be the most absolutistic organization on free speech. We were formed over 90 years ago, and we have played an intrinsic role in pushing our courts to the position that they are now in on free speech rights. We're a civil rights organization, but we're also known for doing such things as defending the right of Nazis to march in American cities. And so, we've always held that, the remedy for bad speech is not suppression, which is often counterproductive and dangerous, but more speech. So we come to the right to be forgotten with a certain skepticism, and I'd like to frame my discussion of it in terms of the panel's theme of time. So perhaps foolishly, given the great depth with which my esteemed colleagues on the panel have thought about this issue, I'm going to argue today that the dimension of time really should not matter. I'm going to make three main arguments why this is so, and then I'm going to conclude with one point about how time may matter. So the first of my three arguments is that other criteria aside from time are the key ones that we should be looking at. Because of the concerns over free expression, the right to be forgotten must be construed narrowly. I should be able to control what I say, but not what others say about me, as one of my colleagues put it, very succinctly, I thought. If somebody wants to remove data, there are certain questions that should be asked to determine if that request should be honored. And in each case where I think the data should be removable, I think that it should be removable regardless of how old it is. And where it should not be removable, it should not be removable regardless of how old it is. So one question would be, was the data created by the subject? If content about me was created by somebody else, then I think that that's a matter of expression and they should not have the right to take it down. What is the nature of the records that the subject wants removed? I don't think that my organization would have any problem with forcing an entity like a company to remove records of its interaction with a subject where records meant business records or was narrowly defined so as not to include things that could inculcate the First Amendment or freedom of expression. But there may be other kinds of records there that would be problematic. Number three is the data held by an entity that the subject had a direct relationship with. I think that any sort of downstream application would be problematic from our point of view. We don't see Google as yet another sort of data controller, but more probably akin to a speaker in this regard. And generally, we see the internet as made up of a big cloud of speakers, with certain exceptions. If the right to be forgotten is not to apply to downstream entities, that's a huge problem because the internet, as Cory Doctorow put it, is the world's most perfect and powerful copying machine. Number four, is the data governed by any kind of contractual terms on deletion? If so, then we probably wouldn't have any problem with demanding a deletion. Relatedly, is the data held within sort of a fair information practice principle regime of purpose, specification, and use limitation? is the data held under specified purposes or terms that no longer hold true. We would probably have no problem with this, and I understand that in Europe a lot of the discussion is in those terms, although this is an abstract question for us because we have no such regime in the United States. It's a Wild West. Is the government held by a government agency? We would have no problem with putting limits on how government agencies handle or are forced to dispose of information. So again, in each of those above cases and questions where I think the data should be removable, I think it should be removable even if it's old. And where it's not removable, I don't think that it should be removable even if it is old. My second of my three arguments is that it's not necessarily entirely clear to me. Okay. Let me speak faster. It's not entirely clear to me that the Internet's memory is inherently less desirable or more harmful or more unfair than human memory. Human beings have hazy memories which shape how we're thought of by our community. And this can bring about forgiveness. Maybe you do something foolish as a youth, but after many years of responsible adulthood, people in your village forget about it and they have a much wholer view of you. But human memory can also be very unreliable and unfair. As Meg shows so interestingly, the Internet does not remember everything forever. Its memory also fades. I know a guy in Washington who, when I first met him about 10 years ago, was distressed because he was tied to, innocently, a major Washington scandal. And when anybody Googled him, his name came up in relation to this major Washington scandal. And he said, I'm just going to have to live with this forever. Now, 10 years later, when I Google him, there are a bunch of other materials about him online, and any ties to that scandal are buried way, way deep. In fact, there may be a new form of practical obscurity today, which is anything that doesn't show up on the first few screens of an Internet search. But the unreliable of digital memory suggests that we may just be trading one inconsistent and unfair scheme of remembering and forgetting, individual or collective human memory, for another. So that's my second argument. The third point I want to make is that efforts at preserving privacy need to remain focused at the point of collection. The biggest privacy protection for us is that for information not to be collected or retained in the first place. In Ivan's terms, some of those first two stages that he described. In the US at least, thinking about a right to be forgotten is distorted by, and we see it through a different lens, by the utter absence of good rules around collection and retention, the creation of huge stores of information about us. And I think that in some ways the right to delete becomes maybe more significant and more dramatic, to use Meg's term, in a country where other limits are lacking or not enforced, and you get a large pool of this kind of illegitimate data. The best privacy protection remains not having information collected and stored in the first place. I think that in terms of privacy activists such as myself, that is where we need to focus our efforts. And we need a non-retention movement. Too often there's an assumption that it's legitimate for companies or whatever to just retain everything, whether it's your cell phone companies retaining location data. Why are they retaining that data? Many Americans don't even question that, and I think that we need a non-retention movement to sort of change those underlying assumptions. So those are sort of the three arguments that I wanted to make. But I wanted to also say that there is one sense in which the dimension of time will be significant. The fact is the rules have changed on the Internet. Many or most public facts about us are now more public and more permanent than they used to be. The line between what's public and private and what's temporary and permanent has sharpened. But over time, people will increasingly perceive and adapt to this new reality, being more careful about what goes online about them, cultivating their online presence. We're in a transitional period now where there is a gap between the way the Internet works and the way that many people understand that it works. There's that gap because they just don't understand the mechanics of the Internet, because social networks tend to confuse our privacy intuitions, making us feel as though we're in an intimate conversation when we're actually speaking in front of 2,000 of our online friends. And our laws are in flux, or in the US, absent. So that gap will close, people will adjust their behavior, and not just subjects of information will adapt, but consumers of information will adapt. People will recognize, will learn that online information is lacking context, unreliable, inconsistent, and distorted, and will discount information that they see online because of that. And this has already been happening for a long time. I want to give you a quote from an American politician. "The new technology has made it literally impossible for a man to start again in our society. It has removed the quality of mercy from our institutions by making it impossible to forget, to forgive, to understand, to tolerate. That was North Carolina Senator Sam Ervin, and he said that in 1970. So clearly this is a long-standing concern. It's something that is not brand new, and we are gradually adapting to it. So this is a sense, another sense in which time comes into play, the iteration of how people react to the internet. The internet is a historical, not a timeless or unchanging thing. So in conclusion, we have a complex and rapidly evolving bundle of social and institutional practices online. It's too early to begin vigorous interventions into these practices that come anywhere near impinging on the rights of free expression. There's a big difference between the forgetting that happens as a result of many small individual actions and creating a conscious power to direct and allow the government to enforce the deletion of memories, which creates a new power which could be very dangerous indeed. And I do feel a very real and deep sense of loss over the erosion of social forgiveness. I think it's a very real, a very real loss. But I think that in many ways it's inevitable. And the steps that we could take that would do the most to restore those values are the same steps that would most collide with the rights of free expression. Thank you.
I think we've learned a lot this morning, but there's one thing about time that is you never have enough. And we tried so hard to keep everyone in time, and many people did a tremendous job, and we also wanted to involve the audience, but we failed in that, unfortunately. I give the floor back to the chair to close this session.
Hi, I wanted to thank the panel and the audience, and I think it was a very interesting view that we got on timing the right to be forgotten, and my apologies for failing to time the panel properly.